Hi, and welcome to the Progressive Hub Show. My name is Jeffrey Sterling, former CIA officer, whistleblower, and contributor to Progressive Hub. I'm pleased today to have a conversation with NSA whistleblower Thomas Drake, who exposed fraud, waste, and abuse and illegal surveillance activities at NSA. And for his efforts, he was charged with violating the Espionage Act, same as I was. He was subsequently pled to a misdemeanor of misuse of a government computer, sort of whatever that means. Hi, Tom. Thank you, and thank you for coming on today.
Thanks, Jeffrey. Thanks for having me on the show.
Okay. Just to have a chat. You recently penned a piece on Roots Action. I think you titled it "The Ghost of J. Edgar Hoover Looms Over 2023," and you were talking about Section 702 of the Foreign Intelligence Surveillance Act, and it's looming either reauthorization or sunsetting. Can you give us a little perspective on what you were talking about there, and why we should really be paying attention to whether this act continues with authority?
It's the whole thing with Section 02. Really, this is 5 years, and then it has, as you said, comes up a reauthorization or sunset or possible modifications, right, before it's reauthorized. That all happens by the end of the year in terms of its enforce mechanism. But of course, they don't want to wait until the end of the year to continue or let's say sunset it. It really grew out of the FISA Amendments Act, and that goes back to 2008. That's where it all started, which actually has its own history in terms of sort of ex post facto, and I'll call it that, legalization of what were patently unlawful, unconstitutional surveillance programs that I was a part of in exposing. Sort of the
and FISA allows the entire collection of foreign intelligence information.
Well, by definition, it's interesting. Even though there's a secret court within a secret appeals court, it was a compromise solution. But it's important to note, for those who will listen to your program, Jeffrey, that it really grew out of all of the scandals and all of the unlawful activities conducted by the U.S. government in secret, which in many cases, especially the surveillance side, have been ongoing for decades. Multiple programs across multiple agencies, all coming out. The Church Committee, the Pike Committee, Bell Abzug, Rockefeller Commission. And so in 1978, they passed under President Carter the FISA, the Foreign Intelligence Surveillance Act, as well as creating two standing committees for intelligence oversight. One housed in the House of Representatives, the other housed in the Senate.
Yeah, the HIPSI and SISI House.
HIPSI, shorthand HIPSI and SISI, which I became quite familiar with as part of my own whistleblowing.
Same here.
Starting early on after 9/11. But again, these super secret programs. So FISA, but it had to be compliant with the Fourth Amendment. So in the event that a U.S. person, and when I was in the military, we had annual training, quite significant. It was annual training, just refresher training, to keep us apprised, because there were modifications made with FISA 5 times prior to 9/11, just to keep up with the times in terms of, or keep up with the technology. But it was always a Fourth Amendment standard.
Yes.
So you had to let's just say, if you violated that standard, there were actually criminal penalties under the U.S. Criminal Code, 18.
Yeah, and the Fourth Amendment, to preventing unlawful searches and seizures.
Unreasonable, and you had the probable cause standard. So it had to be reasonable, but when you're dealing with U.S. persons, which had its own unique definition, because it wasn't just natural-born citizens, it wasn't just U.S. Citizens, it could also include all foreign nationals and I'll say legal foreign nationals resident in the United States or resident in U.S. territories. Because I used to be part of sort of the surveillance regime in terms of listening in on communications of various countries in my past, and incredibly strict protocols were followed. And there was also a special procedure if you inadvertently captured communications involving U.S. persons, which, by the way, also included U.S. corporations. I don't want to forget that. They added that.
Yeah, I mean, a bit of a difference. So, I mean, when I was at CIA, it was hammered onto us. We don't do operations against U.S. citizens. We don't do operations against U.S. citizens. And that if one happened to fall in a net that we may have set outside of the U.S., there were so many standards. I used to also work in the Office of General Counsel at the CIA. There's so many boxes you had to check. So many, to make sure, we weren't violating the law. There was that sense that, we're protecting our country, but we can't violate the laws of our country in doing so.
Precisely, even in what you would call the secret side of government, right? So even in the secret side of government, in fact, you would say there was in essence a more higher standard because it's in secret. There's things you can quote unquote get away with. And so but the Fourth Amendment standard, there was no exception made, and even in terms of national security. Now, there were some interesting provisos. You could, in fact, start a warrantless. This is a sort of original FISA pre-9/11. You could actually start a search and even engage in seizure, right? In terms of evidence, but you still had to get authorization, right? But this was normally if someone's life was at risk or because of the circumstances involved. So that was a proviso built into the original FISA. So Section 702, and it's understandable post 9/11, and then of course all the revelations. Well, what do we put into place in the updated FISA that will allow us to still go after foreign nationals, and if they are communicating with U.S. persons, and that includes U.S. corporations, we still have to follow the standard. Now, if it's just foreign, it was carte blanche. During my day, it's carte blanche. And I think that in part, I'll just sort of parenthetically insert at the moment, when you had free license to pretty much collect anything outside of the U.S. person bubbles, I think you set up a tension, meaning that once those guardrails were lifted post 9/11, right? How are you going to put them back into place? Well, in part, when all this came out, and of course I was part of that, the FISA Amendments Act consolidated and legalized a lot of that, and they had this special section. Now, it also does permit collecting information as part of the foreign national communicating with a U.S. person. The problem, just given the nature of technology, and this is partly why it's so incredibly seductive, if you have the power in secret, well, while we're here, and then they have these things called selectors, which go way beyond just a person, which allows you basically, just sort of take it all, right? We'll worry about it later. So NSA is the one that does that part. And it turns out under Section 02, the FBI is the primary government agency that has direct access to that database. Well, that database is filled with all kinds of information. And they've abused it. I'm going to cut to the chase. They just abused the privilege, because now it's like, well, maybe we can look for other things. What if it's possible crime being quote unquote, or suspicious activity? And yet you don't you're not meeting the Fourth Amendment threshold, and you don't have to go through. In essence, it is a backdoor warrantless mechanism. You can't say it's inadvertent because, in essence, you've already given yourself permission. Okay.
To do it. Yeah. So it's they're looking for a crime, even though there's no suspicion of a crime being there. They're looking for a crime. And it's all in interpretation, especially, if you get a motivated individual who just wants to, I don't know, look good on his review coming up, he's going to find something, maybe make a connection that isn't really nefarious, but they can make it so by saying, oh, well, I found this connection, this U.S. citizen, I found this connection with this foreign national who might be of interest to us. So yeah, I mean, the checks and balances of the Fourth Amendment are, like you said, they're using a back door to get around it. And that's the nature of 702. What I found interesting about 702 is that it's what do they call it? Compelled assistance from electronic service providers. So it's not that they have goes to Google, FBI goes to Google and say, we want these records on such and such. But with it being compelled, they can't say, well, we'll do it with a search warrant. There won't be a warrant. They're compelled to do so. And then if they refuse, of course, then it's going to be a secret court that says, no, you are compelled to do so by Section 702. Regardless of any of the process, where is the probable cause? Where is the Fourth Amendment in this? It's not there, and I think
it doesn't matter.
Point on that.
Or we pay lip service to it because this is you get into the titles, right? The various titles that apply, and so in essence, you get this gigantic carve out because it's for national security purposes. Now, this actually goes well beyond the original purpose of Section 702, which was really going after, quote unquote, threats to U.S. interests. Now, it could be national security interests, but it could be threats to other parts of U.S. interests, not just national security per se. This is sort of protecting who we are as a nation. Well, yeah, sort of the bad guys, quote unquote, just to use that phrase, the bad guys. Well, this goes well beyond just foreign, bad guys that have the label of foreign national.
Yeah, bad guys who we want to see as bad guys. The collectors, if they want to see someone as a bad guy, whatever, having every bit of information, having every bit of communication that they've had. If you want to see that person as an enemy, as a bad guy, there's nothing to change your mind in that sense.
Exactly. And remember, with selectors, and this is where it gets, I don't want to get it too much into the weeds on the technical side. A lot of people don't fully appreciate this. If you go to a particular node, I'll just say kind of a node or a location or a station on internet. I mean, again, there's actually specific language that's associated with a lot of this, but in terms of the net, you can sweep up because of the mechanisms of modern communications, which are, most of them are digital. There's still tons of analog systems out there and point to point, but most of the world's communications have gone digital. So you have vast streams of data where it's a mix of everything.
Yeah, it's incredible.
The U.S., I'm familiar in part with some of the earlier variations of the system, have extraordinarily wide access, not just on a nation state level, but also in partnership with certain other countries. So the access to foreign national information is quite extraordinary. It was inevitable. It's just inevitable, unlike the earlier days, that you would in fact come across lots and lots of quote unquote U.S. person information.
And I think in post 9/11, I think the danger, and what we're talking here is, where does privacy fit within this rubric? I mean, we've just hit the 10-year anniversary of the Snowden's revelations, about mass surveillance. And so, and the reaction, of course, other than government, making enemy number one out of Snowden. But okay, let's talk about the facts of mass surveillance. What legal protections do we have? Where does privacy fit within this? And we have things like Section 02, which, and I like the term that you used in your piece. We're talking about private side. It's the intentional killing of privacy by government initiatives, all in the name of national security.
They just want the data. Bottom line, you strip all of sections and FISA and acts and all the procedural process issues, right? Strip all that aside. The bottom line is the Fourth Amendment is in the way of our ability to, quote unquote, collect information on an unfettered basis. And the trend line is we just keep removing whatever little is left of those guardrails.
Yeah.
And to me, Section 702 basically holds the Fourth Amendment in contempt. It makes a mockery, I'll just say it that way, it makes a mockery of any sense of, quote unquote, personal privacy at a person level.
Yeah, no, absolutely. I mean, do you feel, I think I obviously know the answer to this, but and of course, the impetus for all of this, the government says we need to protect our nation, national security. So you would think there would be laws that could coexist with laws to protect our rights. So do you think that 702 can actually coexist with the Constitution, and specifically, we're talking about the Fourth Amendment?
No. See, this is where the national security imperative, unfortunately, has taken primacy over any. Again, there's sort of black letter law, right? There's the principle, and then there's the practice, right? So you can argue, oh yeah, that's what the law states. Yeah, you're supposed to have a warrant, aren't you? I thought, yeah, well, it's just some vestige, right? You don't understand, in the modern age, and you can say I'm being cynical here. In the modern age, it doesn't matter anymore. And if you've done nothing wrong, if you've done no crime, you don't have anything to worry about. Oh, really?
I want to touch on what you just said, because I think that's how people will view this. Is that, hey, if you've done nothing wrong, you've got nothing to worry about. Well, I think, how is that defined anymore? Doing something wrong?
It's left up to the government, and it's unconsenting. You have no opt-in or out, as it were. You don't get it. You don't get to say. See, this is the kicker where the Fourth Amendment protects you against unconsenting behavior on the part of a very powerful instrument in society, which is the government. It is the government that can put you in prison, as you know. It's a government that can jail you. It's a government that can make life incredibly difficult for you. And I came within an ace of going to prison myself.
I went to prison. So
you went to prison. You know what the power, and it is an intent part to destroy who you are, because you, quote unquote, violated the laws of the land, and in particular, and they seem to even prosecute at a more vindictive level, I'll say it that way, with when you, quote unquote, violate national security rules, right? Oh, okay. So the government can hide itself behind the blanket and the security of national security, right? But no, you're insecure. We'll make everything else insecure. But don't you want to feel safe, Jeffrey? Don't you want to feel that the government is providing, the caretaker, caring for you? It cares enough? No, it doesn't. It doesn't care for you.
Yeah, the sentiment, we're from the government and we're here to help. Help what? You're not here to help.
Well, help what is right.
Yeah, exactly.
I just know, you and I mean, just to say it more in more general terms, and respect, why are whistleblowers, on the short end of the stick here? Because when you're charged of the Espionage Act, it's a strict liability.
Absolutely. You essentially cannot defend yourself.
You are guilty by virtue of being charged. It is assumed that you are already willful. You have no, except that, you can try to mitigate yours at sentencing, but by that time it's too late.
Yeah. And the courts are, and one aspect that is really difficult, and I think it gives even more power to violate Fourth Amendment with things like Section 702, is that the courts are unwilling to challenge the government on, let's start with just classifications. The government is not going to challenge the FBI or CIA on what is considered classified, and they could easily throw that into, that was national defense, so that's related to national security, so don't question what we're doing. We're doing this in the to the benefit of the nation and our national security. And I think 702 is that justification. National security being the reason, and then the illegalities that come out of it, the vehicles of it, are some things like Section 702. And I think the death of it is privacy. And they're using fear, and that's one another point that you made.
Fear. Oh my God, fear is a controlling mechanism. It's a social control mechanism.
I want to
personally and societally.
A great sentence you had is that and you described the reality of it, is that privacy is simply null and void as the government continues to fear pimp for private side. I think that is a very direct and absolutely true statement. Yeah, absolutely. I mean, they're using fear. I mean, and they're striking fear is like, don't question us. And that's, I think, and that extends, I think, to you mentioned earlier the committees that are supposed to have oversight over these sort of the House committee, the Senate committee. When was the last time any representative ran on, I'm going to clean up the CIA, or I'm going to clean up our intelligence community, or anything like that? No, there's fear. You'll be labeled non-American if you don't go along with these measures we're using to protect you. Don't worry about your privacy is essentially what they're saying. And unfortunately, the courts don't challenge it. And even the law. I mean, one great point that you made about Section 702, it's that, courts are supposed to interpret the laws and the history, the formation of the law, the enactment of it, and things like that. But coming up with 702, one aspect that I find really disturbing is how government, FBI is using this aspect of defensive searches. You make a very good point that 702 doesn't distinguish between the Fourth Amendment doesn't distinguish between defensive and offensive searches. Give me a sense of just the difference between those two, and why FBI and other government agencies are pushing so hard for this aspect of defensive searches.
In essence, it's really a bastardization of the Fourth Amendment. Basically, it's turning it inside out, meaning as a defensive mechanism, we think there might be. It is designed to protect. So you're going to see the language that's used. Well, it's national security. We're using an executive power to protect you. Mm-hmm. So we want to be as thorough as possible. Yeah. So the defensive mechanism, in essence, is an excuse as to why I am accessing information. I'm just speaking from an FBI perspective, irrespective of how it was collected, which is a whole nother dynamic here. Yeah. In essence, I have the data. I just go look. Well, for defensive purposes, let's just check more of it out than we knew, not based on, remember, there was no Fourth Amendment where you actually have to clearly articulate before, a third branch of government judge, could be a magistrate, could be a regular judge, could be, right? Mm-hmm. The place, the particulars, what it is you believe is there, right? That it would provide you evidence of a crime.
Yes.
The standard is really high. Well, what if the original basis for why is not there? So you have to, then what's your excuse? It's for defensive purposes. Mm-hmm. Yeah. The best offense is the defense. It's sort of this predicate. It's a use of a predicate, right? Mm-hmm. But it's a use of a predicate for predictive purposes, meaning we might find some activity that we need to go look at. Or, we think that person's suspicious. What's there on that person?
Yeah, absolutely. And, talk about I guess it's them feeling that we're being proactive to protect the nation. Well, did we? Oh, we're back. He'll fix it. I guess the excuse is they're being proactive in protecting the nation. But how many times have we seen instances where done these mass collections, apprehended or arrested some individual based on a suspicion of future activity. And when you hammer someone with, we're going to say, you violated the Espionage Act, we're going to send you to prison forever. You can get individuals like, it's like, oh, they'll plead to something like that because of the fear of facing a criminal justice system that hasn't really shown much interest in civil rights for, I think, quite a while. So yeah, this defensive aspect. And what's troubling to me is that is not in the law. It is not specified
at all.
That is government agencies adding in a definition, adding in a understanding, and it hasn't gone through the process of the courts. And the courts are just saying, oh, okay. And that is very troubling, I think.
But
and
you can understand.
The epitome of that.
Yeah, well, it is the epitome because you understand, because it's warrantless. Yes. By definition, it's warrantless.
Yep.
So if there are no guardrails, I don't have to show any proof. I don't even have to, the affidavit, the traditional FISA, even FISA, you have to demonstrate through actual evidence. You couldn't just say, I need it because it's for national security purposes. That was not an excuse. You couldn't, I need it because that person is suspicious. No, again, with some of the exceptions, right?
Yeah.
But again, even then, you still have to go back to seek the warrant. It was supposed to be an exception to the rule that the privacy of a U.S. person was always protected.
Yeah.
When it wasn't, you had to actually make the case, not unilaterally as the executive branch or with your executive power, which is enormous.
Yes.
And given what's at stake for the person, you have to go to the third branch.
Yep.
They could still eat, but you got to make the case. So I find it, again, post 9/11 and all the iterations here of privacide as the things have developed.
Yeah.
I find it fascinating that in essence, the U.S. government has decided the Fourth Amendment standard is no longer really necessary. It's actually an impediment to protecting the nation. It's an impediment to national security. It's gotten in the way. I remember early on when I confronted the designated attorney. He was, the lawyer in the Office of General Counsel. He was actually the one that was, quote unquote, holding sort of the accountability, at least in the OGC, although he did not authorize, right? I said, what are we doing violating the Fourth Amendment? We can't just bypass FISA. Yeah. And we had specific procedures for all that, right? That had developed over the years. There was even a actual USID. It was a signals intelligence directive that took the FISA and then it implemented that in terms of the specific signals intelligence procedures to ensure you were in alignment with and always consistent with. Never ever would get up to, right? And anything inadvertent, there were certain things you would have to then do to, quote unquote, take care of it. Yeah. You never want to be in a position we were violating the privacy of a U.S. person. But that all disappeared. All this sort of, you've got the shell game, right? You can kabuki dance this to your heart's content. The kicker for me is even when this was noted by even the courts, that there was misuse and abuse, it continued.
It continued. And
the reason,
I'm saying the only reason we know about them is because of whistleblowers, not because of some upstanding individual, passing a law or revealing it. It's because of whistleblowers. No one in the system, who's okay with the system. No court is saying anything to this effect. They're not allowed to. But it's the whistleblowers, and this fear of national security is giving strength, or maybe it's the other way. 702 is giving more strength to that fear mongering and allowing to really be, the death knell of privacy in this country is.
But it also allows them to hold on to that abuse of power and extend it further.
Yeah.
You never can get enough data. I mean, what I was about to say, that general counsel, when I went to him, he said, you don't understand, Mr. Drake. We just need the data. I said, wait a minute, just need the data. We have a whole mechanism. If you're saying that FISA is outmoded, outdated, quaint, right, in terms of Fourth Amendment. If you're saying that, you've got to make the case to Congress. They're the ones that actually create the actual law that can be signed or not signed by the president. And then you've got, obviously, the judicial to interpret and determine whether or not you are or are not, right?
Yeah, absolutely.
That's enormous power. But no, you don't understand. We just need the data. So in essence, they were all really willfully violating the Fourth Amendment from early on because they just needed the data. So you already have the mindset created, which then leads to sort of this pretzel legal, and I put legal in quotes, Jeffrey, this legal logic to justify the Section 702s of the world.
Yeah. And it is something that is placing these individuals, and I think it's gotten to a point of a sort of arrogance that they are above the law. And what justifies that sentiment is national security. We're here protecting. So yeah, 702 places individuals above the law.
How does a rule then take precedence or primacy, or even over law? Those remember, classification is not in the Constitution. It's actually something that's created by the executive branch. But it's a whole set of rules. Why then? And then they backfit again if you end up violating, right? Oh, Espionage Act. Yeah, well, national defense information, I fit just about anything underneath that umbrella. Yeah, but usually it's assumed to be closely held by definition because it's a state secret of some type, whether it's low level or high. Right.
Just because they say so.
But to me, it also allows you to get away because you could have classified secrets. I'm in violation. That was what I faced in my own case.
Yeah.
It was unclassified. They said it was classified, but it was still, even when it was unclassified, it still deserved the same level of protection as if it were classified because it was national defense information and it could severely harm the national security. That keep invoking that phrase. Where does a rule?
Where does it all fit with the law? I mean,
does
just
law
as
matter?
An example for me, them touting national security. When I sued the CIA for racial discrimination, my case was not allowed to go forward, not because of the merits of the case, but the government argued and the courts agreed. Eastern District of Virginia agreed that for me to try or have my day in court to fight against racial discrimination in the CIA would be a threat to national security. And then the interesting thing, turn around when they ticked off at me to go into the committees about a failed Iranian operation, charged me with violating the Espionage Act when information from that was leaked. And everything that I was not allowed to bring forward because of national security, they blatantly gave up all sources and methods of intelligence operations, working with national labs, how operations are formulated at the CIA. All of that was put willingly on the table by the government. So they wanted every way that they can take advantage of it, defensively to stop the revelation of wrongdoing, and offensively to persecute individuals who have the nerve to stand up against them and to say no to their programs or bring up that they're doing things that are illegal. And that's what they're using. That same rubric is what they're doing against whistleblowers. They did it against you, did it against me, and they continue to do it against whoever else. I mean, it's incredible.
You could argue, and I've said this in different ways in the past, but I'll just share this. I'll share this with you for your program and your viewer listeners. The degree to which the government will come down on you, and it's in many cases, a ton of bricks and anvil iron to wipe you out, is the degree to which they are actually violating the law, the degree to which they're actually using national security to abuse power and misuse power.
Yeah, absolutely.
Why would they go to such great lengths to pursue their prosecution of you? Why did they go to such great lengths to pursue the signature case under Obama with me? Why did they do that, right? and then using the Espionage Act. It hadn't been used in this context since Ellsberg, right? I was the first whistleblower since Ellsberg, but it became normalized.
Yes.
That's how much the government desires to protect the pathology of power expressed in the form and under the rubric of national security.
Yeah.
Law doesn't matter here, right?
No.
But they're using an outmoded, unconstitutional, violating the First Amendment law, because it was a leftover from some even worse acts that were passed in the World War I era. But it's now being used as an incredibly blunt instrument. And of course, it's surreal for me, and I'm going to insert this now because of what's going on in the news, that a former president of the United States has now been charged with 31 counts under the Espionage Act.
Yeah. Same for me.
Yeah.
My sentiment on that is that act, charging someone with violating that act, the way it's been used is it's an unjust law, the way it is being used. And I don't think even that former president should be charged under that act. But if it's being used in this way, they had to charge him with violating the Espionage Act.
That's what's all
I think there was no choice.
Yep, so I would agree. And he certainly didn't help his circumstances. I think they gave him, unlike us, multiple opportunities.
Absolutely.
I recognize he's former president, multiple opportunities to take the exit, head to various off-ramps, and he just wouldn't. So that does beg other questions. I think there's a lot more to this case than even what has been revealed so far.
I think so as well.
But I think they were compelled, after all of the attempts, to just send it back.
Gave him every chance in the world.
Every chance. I didn't. It's the irony in my case. I was authorized to retain a few boxes of unclassified that was actually gone through and approved by the security officer. Okay, it's sort of, it's just this two tiers of justice,
absolutely. That is the
two tiers of justice.
Yeah, and so we'll see how those wheels turn when we start getting into the hearings and everything with regard to this. And I think it's going to be a while. Will he be given a sweetheart sort of deal like General Petraeus or other individuals like that? But we'll see.
Or Spiro Agnew. It's probably the closest. Short of, we know Nixon, no doubt would have been impeached. He would have been found guilty, etc. Ford pardoned him, right, for quote unquote the sake of the nation, get it behind us. It was highly controversial then. It was live for me, in terms of when he did that. And remember, Ford was not elected. It's an interesting factoid of presidential history in terms of who ascends to the highest levels of the executive branch.
Never elected.
But you could go to the Agnew the year earlier, 73. You could actually make that is the only historical analog to what is going on right now. Now, he was not charged espionage, but he was charged with all kinds of corruption.
Yeah,
definitely. A peeled plea deal actually was worked out. I recognize his role as a former president, but again, ostensibly, the principle and practice is supposed to be no one is above the law. I guess until they're not.
And until they're not, and that's like too. So just on this point with 702. What about the argument that say, well, we need to be able to do these things to protect the nation? We don't have I think they're saying they don't have the capability and haven't had the capability to face these kind of threats. What is your answer to that?
It's not true, because again, remember, they have this huge database. It's already there. It was just collected by NSA. There's all kinds of questions about even those mechanisms, right? And it's already there. We'll just access it. So 702 just gives them sort of basically the stored access. You get into what's, transiting through versus what's stored, but that, it gets into the weeds.
Yeah.
Personally, the Fourth Amendment standard applies, period. Or if it's not, then let's just be honest about it. Okay. Let's just cede that national security always take precedence, and we'll just let the government run roughshod over any notion, whatever's left of the notion of privacy, because the world is so dangerous and there's so many bad people out there, and everybody is potentially suspicious. We just need the data, because we never know where that next threat will come from, Jeffrey. So,
yeah.
Really?
From my perspective as the CIA, like prior to 9/11, we had the capability to monitor.
Actually, we did.
We had the capability to monitor terrorists. We had the capability to fight them. We had the capability to protect this nation. We weren't doing it.
Yep, we did. We actually failed. There was a systemic failure. We failed to protect the nation.
The tools have always been there. Yeah, the tools have always been there.
No, I'm in total agreement with you on that regard. This is something that's a little understood. They were actually there.
Yeah, and so we get this knee-jerk reaction.
Yeah,
and it's like, privacy be damned. Fourth Amendment is antiquated. We need to protect you. It's this knee-jerk reaction, and because of things like 702, it's just building. The whittling away of individual rights and privacy, or just whittling in the name of being whittled away in the name of national security. And hopefully, if 702 is not reauthorized, hopefully if there's any sort of, and I would imagine there's going to be either amendments to it, or I don't know if it will be blanketly reauthorized, but hopefully not. But at least maybe something will be in place to at least recognize the threat that this poses, these sort of measures pose to privacy, and how important privacy is in this country. So, but yet to be seen. We'll see how things go. But it's been an absolute joy speaking with you today, Tom. I really appreciate the insights that you bring, and the understanding. From a whistleblower's point of view. And I don't think there's many that get that, unfortunately, in this country. But thank you very much for your time today.
No, you're welcome. We both live worlds in which freedom is incredibly restricted.
Absolutely.
And, we're living proof and also living history. And I think that's part of our role in our capacity as whistleblowers. You do raise the alarm bell, and obviously a lot of people don't like it when people raise alarms and bells. They would rather you remain silent, right?
Absolutely.
But there is moral agency, and this is my acknowledgement of you, where the strength and fortitude, right? Yeah, and that there is risk, but then you get taken out by the government, because they decide we can't have you in our midst, right?
Yeah.
But it speaks to larger issues, and I think these are fundamental issues. I would prefer to see, just as sort of a quick summary, 7.2 go away, because to me it's just the continuing legalization, the creep, we call it mission creep of privacide writ large. But writ large, our country, for all of its contradictions, was founded on this fundamental right of privacy. It really was. You just couldn't show up with a piece of paper. Here, we're not even showing up with papers. That's the kicker.
Yeah. So, I mean, what are we? What are we becoming? Sort of thing. I think is the question that we all need to be asking.
Yes,
definitely. So,
and again, keep asking.
Again, thank you very much, Tom.
You're welcome, Jeffrey.
Take care.
Yes.
I guess.